G'day everyone, and welcome to the 14th Agony Anth, part of my collaboration with the Charles Darwin University Law Student Society. In this video, I've been asked, is the legal profession really collegiate? Our legal system, as with most legal systems around the world, is an adversarial system. The whole reason that we need trials and courts is that parties have different, conflicting views about the facts of a disputed situation or the meaning of laws that apply or their obligations under those laws. If there weren't disputes, there wouldn't be any need for adversarial law. It's an inevitable part of human nature that when people are in a dispute, it tends to affect their emotional reactions as well as their logical reactions. Or to put it more simply, people in disputes don't like one another, and it gets personal very quickly. This is the case even for administrative and commercial matters. It's even more the case in family law matters and wills and estates. One service that is meant to be provided by the legal profession is that as lawyers, we are less likely to be emotionally affected by the case, which means we are supposed to be able to keep a clear head and guide our clients towards an appropriate solution, while filtering out a lot of the emotional content that can get in the way of resolution. For this to work, it relies on two ideas. The first is that lawyers are supposed to have their first duty to the court, not to the client. This is meant to stop lawyers from over identifying with their client and being trapped into that same emotional reaction. Second, the legal profession is supposed to be collegiate. We're all supposed to remember, first and foremost, that we are brothers and sisters sharing a professional dedication to the law. Your opponent is not your enemy. And as a matter of logic, it's just as possible that you might have ended up with their client and they might have ended up with yours. So the idea is that by being collegiate, we can represent our clients vigorously without it turning into an unseemly brawl. That's the theory anyway. And if you ever attend professional events such as law society dinners or admission ceremonies, you're quite likely to hear senior members of the profession and judges talking about the collegiality of the profession. There's no doubt at all that in a perfect world, in a perfect justice system, lawyers would be collegiate in this way. But we're not in that perfect world. We're in a world where lawyers do ideologically commit themselves to the rule of law, but where they also have businesses to operate, or where junior lawyers have billable hour budgets to meet. We're in a business where repeat customers are vital and where word of mouth is crucial advertising. These things cut across collegiality, and they cut across the conceptual division between lawyers and clients. For instance, if a lawyer knows that a client is a big client, they won't want to lose. And they might lose their sense of independent thought because they become personally and emotionally committed to victory. So it's reasonable to ask, how much is collegiality a reality in Australian lawyering? And how much is it just an ideological aspiration? Like so many of these ethical things, the answer is complicated. First and foremost, different areas of practice result in lawyers who operate in different ways. Sometimes this is just a result of the way the area of law works. In my experience, for instance, the most aggressive opponents I've come across are family law practitioners. In fact, I've been very surprised by just how aggressive some family law practitioners can be. Some of them have sought to undermine my own professional competence from the get-go, suggesting, for instance, that I had no understanding of the relevant law and that I was advising my clients negligently. It was surprising and quite disappointing. In commercial matters, business operators are used to competition and they're oriented to winning. Sometimes that characterises the lawyers who represent them. Some other areas of law, though, are not quite so emotionally charged. In my experience, administrative law matters, particularly where your opponent is a government solicitor, or commercial matters where the other side are acting for an insurer or another big institutional client. Those matters are likely to be far more collegiate. You're much more likely to be able to sit down and have a sensible conversation with your opponent in those circumstances. Perhaps because the disputes are less about winning and losing and more about finding workable solutions. So, the first factor is the area of practice. The second factor is the type of firm. One thing you'll very quickly learn as you begin to obtain experience in the legal industry, whether this is before or after you graduate, one thing you'll learn is that different firms have very different cultures. Some firms see themselves as aggressive defenders of their client's interest, and they'll be gunning for you from the start. Any lawyer who works in that environment will be required to conform to that manner of practice. It's not that there's a little sign when you walk in saying, remember to be aggressive today, but the junior lawyers take their lead from the more senior colleagues. In addition to this, in the largest firms, the big headline firms, you're often dealing with a junior lawyer who has about 6 people above them who have to sign off on whatever's going on. They're a small cog in a great big machine. You just can't have a straightforward, clearing the air, sensible conversation with that lawyer because they don't have the authority to tell you anything. At the other end of the scale, micro firms, and particularly sole practitioner firms, can often be under immense financial pressure. Losing a client is inconvenient for a multi-billion-dollar international firm, but it can be life and death for a sole practitioner. This can sometimes make it tough for people in very small firms to have that level of detachment from their clients. In my experience, typically the most collegiate folks I run across are those in the medium-sized firms. Firms which are big enough that every client's not a matter of life and death, but small enough that they can have personal and relatively open cultures because there's no need for a big bureaucratic structure. Now, I should say everything is different in the barrister world. Every barrister operates their own sole trading independent business, even though they usually band together in chambers groups to share resources. Barristers, in their relationships with one another, typically come a lot closer to the ideal of collegiality. I've practiced in the city and in regional areas, and there's a view out there that regional areas are more collegiate. I'm not sure that this is a view that can be accepted uncritically. Certainly, the legal community in a regional area will be smaller, and so people will very quickly come to understand who you are and how you practice, including whether you tend to be collegiate or whether you tend to be aggressive. However, even in regional communities, there seems to be a range of approaches to practice. It's just that everyone knows everyone a bit more. Finally, of course, the last factor is the individual lawyer. Some lawyers are aggressive by nature, and those lawyers seem automatically to end up in the areas of law populated by other aggressive lawyers. Some lawyers are collegiate and cooperative. Some lawyers are collegiate and cooperative when things are going their way, and then they turn into horrible creatures when things are not. From this perspective, we can circle back to the area of law. If you're in a boutique area of law, where you're likely to come across the same opponents over and over, then it makes sense to establish a reasonably collegiate working relationship. If opposing another practitioner is just a one-off thing, then the same reasoning may not apply. Ultimately, though, lawyering is just like any other trade or profession. Some people are great and others are jerks. One thing you'll discover in the profession is that there are a range of different lawyers' organisations that you can join. These are as varied as the labour lawyers, the Family Law Practitioners Association, human rights lawyers, various women's legal groups, groups for young lawyers, and so on. In many cases, you can even join these organisations as a student. These organisations do often provide actual collegiate experiences. Lawyers meeting in these organisations are not involved in disputes against one another, and so there's a bit more room for collegiality. It's not clear to me, however, whether that collegiality genuinely continues when you go back to work. So, where does this leave us? Is there collegiality in the legal profession? Well, I would say there is, and there's probably as much collegiality as we could reasonably expect, given that the fundamental dynamic of our justice system is adversarial. If you look for collegiality and contribute to it, it's out there. However, the pretty and aspirational speeches that you hear from time to time about the collegiality of the profession, they're probably a bit too enthusiastic and overblown. Collegiality's out there, but it's not everywhere. Whether that changes in the future is up to you and me and everyone else who participates in our profession. I hope some of you found that discussion useful and hopefully not too pessimistic. It's not intended to be pessimistic, but I don't think I'm helping by pretending either. Keep those questions coming, and I'll try to keep the answers coming too. I'll see you again soon.